So, Renato, does Trump have a chance of being acquitted in the Manhattan DA's trial?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet.
Let the games begin.
No kidding. I got to say, this is a historic day, right? We're recording this on the first day of jury selection in the first criminal trial of a former president of the United States. I have to say, it's not how I imagined this to be, in the sense that, you know, this is not the case. I think that I would have chosen to go first. I know there's a lot of people spilling ink talking about that. It's also a case in which it feels, it feels like it kind of snuck up on us a little bit, right? Maybe because of how all the calendars worked out. It's like, oh yeah, we've got this case and it is going to trial.
Yeah, this was sort of the stealth case.
Exactly.
While
right.
These other ones were taking up a lot of our time and attention. I have to say, I don't mind that this one goes first.
Why is that?
There's something to me that's fitting about, to me, I'm thinking about it in terms of sort of the narrative arc of the Trump crimes, you know what I mean? And to me, this is sort of the gateway crime, really, of election interference. And I think the fact that it concerns behavior from before he came into office, it sort of sets the stage for what's to come. So I don't mind it. And I think it's one that's relatively easy for people to understand. They remember what happened. I mean, they might disagree with whether it should be prosecuted or not, but in terms of really understanding kind of what the crime is, it's pretty self-explanatory. And I think it gets it out of the way, because I would think that probably the January 6th case, if any trial moves forward at all before the election, would be the next one. And I think in some ways this sort of helps kind of focus attention so that by the time that case comes up, people will really, especially depending on how this turns out, people will really be paying attention.
Yeah, I think that those are all fair points. One thing that I do want to kind of highlight here is you've talked about, people disagreeing about whether the case should be prosecuted. There's a difference between the strength of the evidence in a case in terms of whether you can get a conviction, and then the question of whether you should bring the case. In other words, there's a lot of debate. I feel like we've discussed, should this case have been brought, and we've had a lot of back and forth on it. But now, when you ask me the question at the beginning of the show, you're like, well, does he have a chance of acquittal? I think in terms of the very narrow crimes that have been charged here, that I think Bragg's got a lot to work with in terms of the evidence here. The question is, whether he should have done it, I don't know. But there's no question that there is substantial evidence here. And I think it starts with the false statements themselves. In other words, the crime is in this trial, the falsification of business records. And I don't think there's any serious question that there are false business records here, right?
Right. I mean, we have sham invoices that were presented by Michael Cohen to the Trump organization, and those were recorded and then paid out. I think for each invoice, there's like 2 false entries, basically, given the way that this was proceeding. I think, as we've discussed before, it seems like the big question is going to be whether Bragg can prove that Trump knew about those false entries, because those were really in the ledgers of the Trump organization books, basically. I mean, I guess maybe that's a question for you. Does he just have to know that those entries were being made? Would he have to be more involved in the making of them? Because I doubt that he would be. That to me seems like the big place where there could be some doubt.
Yeah, I actually think there's two significant areas of where there can be doubt here. One is what you just highlighted, Asha. I think you're right to focus on that first. In other words, did Trump know about these entries? Did he cause those entries to be made? Was part of the scheme that those entries were going to get made? Or was he just unaware of that? In other words, it may very well be. I mean, I think a very viable and plausible defense for Trump is, yes, I was trying my best to hide these allegations. That's not a crime, ladies and gentlemen. Paying off somebody not to talk to the press is not a crime. But I did not know that this was going to result in false entries in the books and records of anything, because that's not my job. That's not what I was focused on. I was president at that point in time, and I was really focused on other things, much bigger, weightier things. I think that's a very plausible defense. The problem for the defense is that I think to make that case well, or that defense well, you have to put Trump on the stand. If you don't put Trump on the stand, you really have to rely on other witnesses to come forward and say, well, Trump wasn't paying attention to things at that time. Trump was out because he was focused on the presidency. You have to use other people to tell that story. It's much less compelling, and it really would highlight the fact that Trump himself is not testifying. And then the other possible, I think, very plausible defense here would be it's a semi-defense, is that this is really a misdemeanor because there's no other crime this was in furtherance of. In other words, we put it, yes, we didn't want to highlight this hush money payment because it was embarrassing, so we hid it. But we weren't hiding it for a campaign finance violation. The election was already over. We didn't care about that. It was just we were hiding it because it's an embarrassing detail and we didn't want a ton of press on it.
Yeah, I think, and that's something that was floated even at the time, because for our listeners, the way that this gets bumped up from a misdemeanor to a felony is if Bragg can prove that not only were these false entries made, but they were done with the intent of concealing another crime. We can get to this in a second, Renato. He doesn't have to either identify or actually prove the other crime, I think, or he can sort of be very vague about it. But presumably those are either New York or federal election law crimes. But if he can't do that, then as you just said, it's a misdemeanor. And this is where the whole catch and kill scheme comes into play, right? So this is where the fact that this was a broader pattern of conduct, where David Pecker of AMI and the National Enquirer had been burying stories that, could cast a bad light on Trump during the campaign, and it was dubbed this catch and kill scheme, that the Stormy Daniels payment was a part of this, belies the idea that this was really, he was just trying to protect Melania from finding out. And also, I think the timing, right? Because I believe this was, the affair went back a while before that. And I believe that Stormy Daniels had even told her story at some point, back in 2011, 2012. And, they had never really done anything about it because no one was paying attention to it at that time. It was only on the eve of the election that they decided to, do this catch and kill for this story. So I think the bigger pattern and the timing is what Bragg is going to have to really emphasize to say, no, this was embarrassing, and he just didn't want his wife to find out.
Yeah. So, and just to be clear, you mentioned about the other crimes. I was very publicly critical. I wrote a column that I know was very much focused on within the four corners of the Manhattan DA's office, criticizing them for not specifying what those other crimes were. I just thought that was not only unfair to the defendant, but not right in terms of the public. I think the public needs to know exactly what the charges are here. But they did in a later filing, they kind of walked that back, and they did specify. And you're right, Asha. Their focus, they named a number of crimes, but it sure looks like the focus is the federal and state election crimes. But like I said, it's an interesting point. I'll say is that the falsification occurred when he was already president. So it's more of in many ways, how the impact it might have in the 2020 election versus the 2016, because the payments occurred before the 2016 election, but all of the cover up, or a good portion of that cover up, was while he was already president, which is, I think, a very interesting, facet of this story.
Why does that matter?
Well, the point is that he was not. It doesn't matter for purposes of the campaign finance offense, but in terms of how you explain it to the jury, you're not going to say he was committing a campaign finance offense to influence the 2016 election. It has to be he was committing a campaign finance offense because he wanted to conceal this from the public because during his presidency, or he was looking forward to the 2020 election or something along those lines.
Well, I disagree. I think what you just said actually cuts the other way, right? I mean, he tried to bury the story in advance of the 2016 election. He did not want the story to come out. Now, it's true that if concealment happened after, but I think actually that also is bad for Trump, right? Because if this was just, I didn't want Melania to find out, I just wanted to keep this quiet, it had nothing to do with the election, then why do you need to cover up how it was paid back? I seriously doubt Melania is looking at the books, right? I mean, Trump could have, I don't know, just paid him back. It could have just been recorded as a reimbursement for this whole thing. In other words, why characterize it as something else unless you're after the fact trying to conceal this deception that you made before the 2016 election. I think the deception is not letting the information come out. That is what influenced the election.
Yeah. Okay. 2 points. I mean, and obviously I'm making the defense's arguments here, I'm not stating my own views, but I think the defense's argument there is going to be, well, the reason that they had to conceal this is because an enterprise, that people would leak, if this was apparent from the books and records of the Trump organization, it would ultimately get leaked to the press and there would be stories and it would become national news because he was the president of the United States. I think that has to be their argument.
But how would anybody be looking at the books?
Well, lots of employees have access to the books and records. I mean, there are people who leaked Trump's tax information, right? There's an IRS
those are
employee
public. Those are provided to a public agency.
Yeah, and there's lots of disgruntled employees. And so,
don't forget that the Trump org was convicted for criminal violations for literally keeping a double set of books, one which actually documented their under the table payments to Allen Weisselberg. So I don't think that they're really concerned about I think they thought these books would never see the light of day.
Yeah, I what I said was what I think the defense argument is going to be. I predict that is what the defense argument is going to be. All right. I think that's an accurate prediction. Secondly, the other thing I would say is, I mean, with the defense, you're going to hear a lot of, another prediction over the upcoming weeks is you're going to hear a lot of the defense stressing the fact that the cover up itself that you're talking about that influenced the election was not itself illegal. That's not what he's charged with, ladies and gentlemen. What he's charged with is making these false entries in the books and records of the Trump organization. That didn't influence the election. No one really knew about that. That was done after the election. And it was done, because we didn't want the press looking into things because the press comes after him all the time. That's what they're going to say. And I think there's something to it actually, but I don't think it's going to carry the day here. I actually think that in terms of just looking at the statutes and looking at the evidence here, and that's why I started with this, is that there's a difference between whether you should charge it and you shouldn't versus whether you have the evidence or not. In other words, I think Bragg has the evidence. It's like a cop who pulls you over for speeding and you're like, oh, come on. I'm like literally trying to get to my daughter's wedding. But, was I speeding? Of course. Right. And I think that's the reality here. I think it's going to be a tough case for Trump.
So this will really turn then on the jury. And I'm curious, what do you think is going to unfold during jury selection? Now, it's my understanding that they are not allowed to ask directly about a potential juror's political views.
Right. So let's just talk about what jury selection looks like. It does vary from courtroom to courtroom. Yeah, it varies between federal and state and from state to state, but it also varies between courtroom to courtrooms in literally the same courthouse. So how one judge might handle jury selection is different than another. Judges have some latitude in how they handle it. And actually, one of the first questions that a trial lawyer is asking, I'm asking judges at pretrial conferences exactly how they handle voir dire. But here, the judge put out, I think, a 42 question questionnaire to the jurors, getting a lot of information. The judge will be asking questions about everything from what shows they watch and whether they're part of the Proud Boys or whether they've attended Trump rallies and so on. And then ultimately, it's going to be up to one side or the other to say, or both sides or both sides to make a motion as to whether or not the juror should be stricken for cause. And they could do that for an unlimited number of jurors. And they're basically the standard is not what I think sometimes it seems in the media. It's not that the jurors never heard of Trump. It's not whether the juror knows nothing about the case. The question is, can the juror set aside whatever they have heard or whatever they do know and be fair and focus entirely on the testimony and the exhibits that come forward at trial? That's the test. So I expect a relatively small, like smaller than you might think, number of jurors that are stricken for cause. And then both sides have a strike. And I believe the prosecution has less strikes than the defense. That's how it is in almost every jurisdiction. And that shapes their strategy. And so essentially, judges vary in terms of how you exercise the strikes. Do you do it simultaneously? Do you get to see a group of jurors before you exercise the strikes? Or do you have to see one juror at a time and then make your decision? That depends on the judge. But it's fair to say broadly that the defense has more of an ability to shape a jury to its liking, and the government is usually more focused on trying to just prevent wild cards from being on the jury.
So I'm going to guess the defense is going to want to try to get older white men who are professionals, businessmen. That would be, or even
uneducated.
Class, I guess.
Yeah, he does really well against people who haven't gone to college, right?
He does politically. I'm just wondering for this case, though, right? This is a falsification of business records. I feel like, I don't know, somebody who's self-employed, somebody who, the idea of like, oh, come on, everybody fudges their records. Like they're going to go after this guy that, they could go after the little guy, that kind of thing.
So one thing I'm just going to say as a preface before I make any comments is that jury selection is actually about biases and making prejudice and prejudging what people are going to do based on sort of the odds and what groups they're in. So it's very counter to the way that we should approach the world and the way we usually do. So you essentially look at people and make very snap judgments based on very limited information. And, I think the Trump team is probably going to be looking for what I'll call, and I don't mean this in a pejorative way, oddballs. Like, in other words, people who are unusual, people who don't march by the beat of the same drummer as everyone else. In other words, people who do not accept authority, people who question what is presented to them, people who see things from an alternative point of view. I think that is really important for Trump more than anything else, because I don't know, for example, you say business people, I don't know how that cuts. A business person could be like, hey, my books are straightforward. You never know. But I think he wants people who might get hung up on some small thing in the case. Like, you're not really hoping. And that's why when you asked me the question at the beginning of the show, is it complicated? I think it's complicated in the sense that I think for Trump, a win is a hung jury or a misdemeanor. That's how I would, if he was my client, I'd be like, look, we can't look at this as black and white, man. The reality is, if I can get one juror to say you're not guilty and they got to do the whole thing over again, it's a win. They came at you and you walk out of the courtroom a free man. That's a win. If they get you on a misdemeanor, you can sell that, right? That's a win too. They came at you with 30-something felonies, you're convicted of a misdemeanor. So I think their jury selections to be focused on hung jury.
That actually brings me to another question. So there's 32 counts, right? one for each false
Something like
entry. Do you feel like, I mean, it seems like it would have to be across the board. You know, if they don't find the intent to commit another crime, then none of the felony counts can stick.
Oh, my sweet summer child. Here's the reality. Jury verdicts don't always make sense. I've had times. I was at my last trial when I was a federal prosecutor. I was against a large real estate mogul, not quite as big as Trump, a guy who was worth 100-something million. And the jury found him guilty on half the counts. And it didn't make a lot of sense because, like, if you're guilty on wire fraud because of one wiring, it should be the same other. Like, it's the same case. It's the same fraud. It was just a compromise, I think. They just decided there was some holdout and they're like, screw it. We'll do half and half. And that guy agreed. That's probably what happened. So I think these things sometimes don't make sense. And it's very possible he's going to get convicted in some counts and not others. And there's an old saying that has gotten passed down from prosecutor to prosecutor: one defendant, one count. In other words, if you get a conviction on one count, you got him. And you got them tagged with the felony, and they're going to go and get sentenced, and you've accomplished what you want to accomplish. And that's why it's so hard for the defense, because you effectively have to get the jury to select not guilty 30-something times. Prosecution just has to win once, which is a challenge.
Yeah. And what about the threats that he's been making? Not threat. I mean, basically, whenever Trump attacks somebody, I consider it a threat. But, you know, he seems to be violating the gag order.
Yeah.
I think that against him. Is that just, are we back to where, like, he gets to get away with it because he's Trump?
I don't think it's just that. I mean, I got to say, sort of. I mean, I got to say, didn't we have this debate, was it 2 weeks ago, Asha, and which I said I thought gag orders were mostly a waste of time. They're questionable legality. They're difficult to enforce. I view it in this case like you just deal with it. I honestly think Judge Merchan should waste as little of his time as possible going back and forth on these gag orders. It's fine. You can, like you said, fine him $5,000, $10,000. Like, yeah, if you're worth hundreds of millions of dollars, how much does that matter to you? I mean, he's paying each one of his lawyers that much for an hour, probably, of their time. Like, or a few hours of their time. I just don't think that really is going to drive his behavior. So I expect to see that continue, and litigating that issue just takes time and attention away from the main issues in the case. And so the DA's office seems very intent on pushing that. I think it's mostly to highlight his bad behavior to the judge and drag him in front of the judge. And I totally get that. That's what prosecutors should do in this circumstance. But I think that's all it really is. And I think if I was Judge Merchan's law clerk, I'd be like, Judge, let's just put your head down and get through this trial. Once he's a convicted felon, then, in other words, the judge has all the cards. We were talking about this last week with Judge Cannon. She's in power. It's sort of like your kid whacking up. Like, okay, say whatever you want. Like, you're still not going to have dinner with your boyfriend, so you can say whatever you want, little girl. But I'm the adult here, and I think that's what Judge Merchan, he's in charge, so he should just act that way and push through.
Well, it's all fun and games until somebody gets hurt.
Indeed. All right, Asha, I need your help. All the Republicans are tweeting about Section 702 and FISA. I don't know that much about it. So
neither do they.
And so, yeah, tell me what is going on. What has gotten the right wing so up in arms about FISA? I thought that was wasn't that like 2 seasons ago?
Yeah, it's no seasons ago, because 702 really hasn't played a role in anything involving Trump directly. But it seems to be a convenient thing that Republicans can pile on, or at least the MAGA Republicans can pile on to kind of, I don't know, obfuscate the issue as always. I mean, I think part of the problem is that Section 702 is kind of very technical and, wonky surveillance program that is very hard to kind of explain to the general public. And people often conflate it with Title I of FISA, which is the electronic surveillance we were talking about during the Trump investigation of Carter Page and of Sergei Kislyak. Basically, Title I of FISA is sort of your OG FISA order, right? You have a foreign power, an agent of a foreign power. You go into a FISA court. You show them probable cause. They give you permission to electronically surveil. And this is basically the exclusive means by which you can conduct electronic surveillance within the geographic boundaries of the U.S. Section 702 came out of the Bush administration's surveillance following 9/11, where they were secretly having NSA intercept communications where one end of the call was in the U.S. and one was abroad. A good number of these should have been, would have fallen under the original FISA and would have required these individual court orders. But of course, the Bush administration just ignored that. They relied on Bush relied on his commander-in-chief authority and other Article II powers to do this. And then the lid was blown open by the New York Times and, they were busted. But Congress didn't want to tie the government's hands. And so a version of this that sort of comported with the law was passed. And basically, Section 702 allows NSA to electronically surveil targets that are going to return foreign intelligence information who are non-U.S. persons and reasonably located abroad. Now, this doesn't seem very problematic. What makes it, I think, controversial is that unlike the Title I FISAs, where you have to go into court for each individual person, in Section 702, the government goes in once a year and basically presents the FISA court with a set of procedures where they say, here's how we're going to figure out whether someone is a non-U.S. person and reasonably located abroad. We promise that those are the only people that we'll surveil. Here's what we're going to do to make sure that we don't inadvertently, target American citizens, et cetera, et cetera. And once the court signs off on that, the government is good to go for a year. And so they're allowed to more efficiently target hundreds of thousands of people in a way that they can't if they had to go into court for each individual person. And just to give you like a reference, in 2022, there were about 249 individual FISA orders that a FISA court approved. There were almost 250,000 individuals targeted by Section 702. So
wow.
It's a difference in scale. And what the privacy advocates, I would call them zealots, and the MAGAs, to the extent that they understand it, I'm not really sure if they do, what they don't like is that when all of these communications are being swept up, you are also sweeping up the incidental communications of U.S. persons, potentially, which means, Renato, if you're talking to a Chinese spy or an ISIS terrorist and Section 702 is targeting that spy or terrorist, then your communication with them is going to get swept up. And that is what they feel is a violation of civil liberties. Again, this happens with any kind of surveillance. I mean, you did Title III criminal wiretaps. That happens in the individual FISAs. That happens. But I think it's the scale at which this is happening that they believe that too many U.S. person incidental communications are being swept up. And this is what they feel requires additional Fourth Amendment protection before the government can access it.
Yeah, just to sort of kind of look at this from a high level, just to set some the stage for our listeners a little bit. The Fourth Amendment prohibits unreasonable searches and seizures. And the question of what's reasonable or not is not a black and white sort of thing. And I hope that people are seeing that in your analysis, Asha, because you're talking about essentially a bunch of procedures that minimize the potential inadvertent interception of non-U.S. people, and
of U.S. people.
Or excuse me, of U.S. people. Thank you.
Yeah.
and I guess, and by the way, just to make that clear, the United States Constitution does constrain for example, the activities of law enforcement within the U.S. targeting U.S. citizens. It doesn't really say anything about what the United States government does to, let's say, German people in Germany. And that's really what this is about. In other words, the United States can spy in Germany, and it's not like German people in Germany are protected by the United States Constitution from whatever the CIA decides or the NSA decide that they want to do there. The key issue is just, how do we prevent constitutional violations that are inadvertent? And I will say, this is the case. You drew the analogy of Title III, which is a domestic wiretap statute that, of course, I sought many different wiretaps in my day when I was a federal prosecutor. And, there are similar sorts of, like you said, similar sorts of protections in those. What do we do if we happen to hear an attorney conversation? What do we do if we happen to hear a conversation that's totally innocent between like a subject and their girlfriend, or, their daughter, or something like that? How do you handle that? And then there are different tools that you have. Let's say a roving wiretap, where, if somebody's throwing away their phones all the time, am I able to just get a wiretap order that lets me follow that person from phone to phone to phone? That would be nice. But of course, it's got additional protections and has additional requirements, because you don't want law enforcement to use that all that much. I think that there actually, here, my perspective on this, based on what you're telling me, is that actually there is room for a reasonable debate about what 702 should look like. It's just that I suspect the MAGA folks who are tweeting about it that appear on my timeline are not really interested in that sort of nuanced debate.
Yes, I think that the nuanced debate has to first acknowledge the Fourth Amendment principle that you said, which is, especially in the national security context, what a FISA court is doing is determining reasonableness. And they are balancing the national security needs of the government and the executive branch against civil liberties. In other words, they understand that it's a balancing test in that context. And so they're determining reasonableness. And I think it's important, just if there's one takeaway that all of our listeners could please take away, is the FISA court does not issue a warrant in the Fourth Amendment sense. It is determining that the seizure, the search and seizure, is reasonable, and it therefore gives the government permission to order communications service providers to capture communications on particular targets. I'm sorry, it's a pet peeve of mine when people call it a FISA warrant, because it's dumb. Anyway, so you have that reasonableness standard, and I think, to the extent, and FISA has, or Section 702 has been tweaked a lot over the years to try to minimize those inadvertent, capturing of U.S. person communications. I think where things go off the rails is that when you have people who believe that the government is a bad actor, no matter what. In other words, it's not that there are procedures that, may end up capturing too much, or, and we need to tweak it. When they say, no, but the government is secretly doing X, Y, Z, no matter what you do procedurally, you just basically have no way to win. And I think with this particular tool, I should emphasize that we have an asymmetrical advantage over our adversaries with Section 702. Because the way that fiber optic cables were laid out in the late 80s and 90s, much of the world's communications traffic goes through the United States servers. So in other words, we have the ability to capture communications on adversaries and hostile actors in a way that they can't with us. They have other asymmetrical advantage. This is one that we have. And it just is shocking to me that people don't want us knowing what China is doing, when they're targeting critical infrastructure, don't want us knowing what ISIS is doing. I mean, it's kind of crazy. And like I said, I don't understand the end game unless you either fundamentally don't understand the program or you want something bad to happen to the United States. I don't know. I can't think of any other realistic interpretation of wanting to do away with this entirely or basically render it impotent.
Well, the people, I think it is certainly, I think it's possible for people to have reasonable debates about the limits of what government could do. I think that's totally legitimate. And I actually encourage people to question what the government does. I think that there's an important distinction, though, to be drawn. And I think, this also reminds me, or as you're talking, Asha, it makes me think about what Edward Snowden did, because a lot of people were praising the fact that he was releasing information regarding, surveillance of Americans or bulk surveillance, but I don't hear nearly as much discussion about the fact that he disclosed national security secrets of the United States, particularly our interception of foreign powers and adversaries of the United States. And so, from my perspective, I do agree with you that there has to be a distinction between how we think about our government's surveillance of Americans or monitoring of Americans and limits on law enforcement and things along those lines versus limits on what the United States government can do to make sure that we're protected from foreign adversaries.
Yeah. And I will add here that Section 702 was created precisely because of the abuses, basically, that the Bush administration was engaging in that were exposed by Snowden and what he revealed, right? In other words, it cabined this executive authority. And as far as I'm aware, Section 702 and FISA more generally is, I think, really the only intelligence program where you have input and regulation by all three branches of government, constant audits, reports to Congress, compliance requirements. I mean, it is so regulated in a way that, we don't for drone strikes, for example, which, by the way, technically speaking, the executive branch can target American citizens for that too. So, we have this highly regulated tool that has so much oversight. And one thing that people should understand is the executive branch has never relinquished its claim that it has Article 2 authority to engage in warrantless surveillance for national security purposes. So if you were to eliminate this tomorrow, what you're really asking the executive branch to do is to go back and do it secretly by executive order. And then let the court decide it, because the Supreme Court has never definitively ruled on whether there's a national security exception to the Fourth Amendment. So I just think that it's, when people look ahead to the election and who might be occupying the Oval Office, would you rather, it's the devil you know versus the devil you don't know. I mean, this, at least you're getting constant data. You have the FBI and DOJ having to go in front of a judge. To me, that even to the extent that you question the government and what it's doing, that to me is a preferable scenario than a big black box that you never know about.
Yeah, I think that if you're a civil libertarian, you should be trying to amend and change the law. You don't want to have no law whatsoever. The enemy is not having a law in place. The issue may be what level of oversight is required, what information should be disclosed to the court, and so on. I will note, I believe Donald Trump supported this, or the Trump administration supported this.
Yes, he approved the reauthorization in 2018. He clarified, actually, in a tweet at the time, this was not the kind of FISA that was used to surveil my campaign, and this is what we need to fight our adversaries. Of course, last week, he wanted Congress to kill FISA, Section 702, claiming that it was used to surveil his campaign. So there's always a tweet.
Yeah, and exactly. And that's perfect ending here. It's essentially a bunch of these people are focused on this because Trump is telling them to. So Asha, so for everyone watching this on YouTube, part of the fun is, although I wear the same hoodie every week, Asha looks different from episode to episode. Your hair looks great today. I don't know what you did, but something happened.
So this is actually my natural, hair, which is kind of a little bit curly and wavy. I usually straighten it. But that's because I crammed in a workout before we got on, jumped in the shower, and just kind of like quickly, blow dried and air dried my hair before coming on. But I think it's kind of interesting because it gets to the differences, I think, between in men and women in camera readiness.
Yeah.
And I would love to know, Renato, what you have to do before you get on camera, whether it's the podcast or CNN or MSNBC or whatever.
Okay, that's fair. Well, I'm going to say a couple of things in my defense, because I don't. It's apparent that I don't put nearly as much effort as you. I do make sure I do try to at least make sure that my hair is done in some regard, like it's combed and whatever. Like I didn't wake up and my hair didn't look like this when I woke up this morning. Occasionally, if I have like a 7 a.m. hit or something along those lines, TV hit, sometimes it's going to be kind of rushed, but I will at least try. Okay. Which is for me a big deal. I put a low level of effort. I actually did start going to a better barber for my beard after this was something that my wife convinced me to do. I was essentially for a while going to like a place that did like $7 beard trim, or I think you could have done it at home. It's like a Flowbee or something, it's like just put on a setting and whatever. So now I go to a real barber, but I'm not putting a lot of effort, right? There's no makeup that I put on at home. And I'm just throwing a jacket on and a dress shirt. And I think it's fair to say that the expectations on men and women are very different when it comes to their appearance. So I don't want to suggest otherwise.
Yeah. I mean, for me, if I'm going on TV, I have to set aside at least 30 minutes, 45 minutes ahead to kind of do hair, makeup, and get camera ready. Now, I'll be honest, I usually don't wear makeup for this podcast. And I have a colleague who was shocked by that because she saw the YouTube and she's like, oh my gosh. She's like, you don't wear makeup for your podcast. You're so brave. She's like, you look great, but you're so brave. And it's not that I don't love our viewers, but it's like, I don't love putting on makeup. It's a lot of time. And to me, I don't feel like it's fine if I'm like doing my 10-minute hit. When I'm just chatting with you, I don't like being all dolled up, actually.
Yeah.
And I'm okay.
I'm the same way. I mean, I don't like, I mean, I'm wearing a hoodie now. I was wearing a suit just before this because I had 3 different TV hits because it's the first day of this trial. And I'm like, let me get out of my jacket. I don't want to be in a suit jacket for an hour talking to you. This is relaxed. And that's sort of the point of it. But, and I'm like this with my clients, like people who are paying me a lot, or my law firm, a lot of money for my legal services. If I know you, I'm going to be just like wearing something comfortable. Like,
yeah. Well, it's interesting because it's tax day. I will point out that with regard to clothes and makeup, frankly, if women can't write off, even if they're doing news as a part of their job, they can't write off all, the makeup, the hair, the clothing, etc. Even though, frankly, it's way more expensive being a woman in this arena than a man, because like you can probably wear the same shirt and tie if you wanted to, and no one would notice. And it's less now because I'm doing it from home. But, I used to go into the studio a lot during the height of all the Trump stuff. And I had to get so many different dresses. You can't wear the same dress. People notice what you're wearing in a way that I think they don't. I don't know if people notice your ties and stuff, but
some.
I don't know. It was an expensive proposition. But the IRS does not let women deduct all this stuff.
Yeah, there's a lot of unfairness about what you can deduct or not. But I think it's just there's an unfairness. We could talk more about it maybe in a subsequent episode about what, kind of how women have to navigate the world in general, right? I mean, as a guy, I can sort of more or less just be myself and present in the way that, that I am as a person. Though I think there are some, I will say over time I've certainly have learned over time a certain way in which people expect a man to present themselves. But I think for women, it's always more complicated and you're judged more based on your appearance, for better or for worse. And it just makes it more difficult. It's like going through life on hard mode.
MSW Media.